Justice Sanjib Bannerjee to help us with the next panel. It's on thinking about appellate courts and thinking through issues of reform in the appellate court system. We have three speakers. Nick Robinson and Sidharth are doing similar work, but they're looking at two different issues using similar data. Arun's presentation is quite different, and the speaker bios are all in the pack that's been handed over to you. So may I just invite Justice Sanjib Bannerjee to come up and start.
Good morning. I must say that I'm at a slight disadvantage over here because even though I have always been clamoring for honest judicial statistics, I haven't had access to it. And I'm waiting and I'm searching. But I'm very happy that people are working with numbers, and I was talking to some people just now during the tea break that we had that we are at the very rudimentary stage. We just have some numbers. We don't know the honesty of the numbers. We really have to discover the tools to analyze the numbers to get us to some kind of conclusion that will give us a direction. But I believe the speakers are going to discuss numbers and analyze the numbers, and tell us what the numbers show and direct. But I'll make some comments on some basic issues, which we need to address. One of the fundamentals is that I believe that there may be a problem of quality in our judicial system. And it is better to acknowledge that there is a problem of quality than to be in a state of denial. More often than not, we are in a state of denial because of what some people perceive to be the right reasons, that let's not expose the system in such a way that public confidence in it would be eroded. There are others, of course, who have their own reasons not to expose themselves and consequently the system. But then let's take even the good side. But if we are in denial, then we don't take measures to improve the system. Talking particularly about the appellate stage and the superior courts, I do not think we have the appropriate atmosphere for deciding appeals. I can speak of high courts where we deal with the appellate jurisdiction more often than not, unless we are dealing with the writ jurisdiction, or some high courts have original jurisdiction. We deal primarily in appellate matters. Typically, one of the senior judges will preside over an appellate bench along with one of the junior members, and typically probably one of the recruits from the district judiciary who's been promoted to the High Court. Now, this system itself is not conducive to a proper decision-making atmosphere. That is because of, again, something that I repeat at places I go to, a kind of a caste system that we have in our system. There is a self-deification by judges, and which we tend to preserve. There has to be an amount of respect for a particular post, but you cannot deify yourself to the extent that you insulate yourself from any form of even constructive or positive criticism. Now, typically, a senior judge would have been probably the guardian judge of a particular district. The district judge who's been promoted as a high court judge would probably have been answering to him or would otherwise have been amenable to his administrative directions. Now, this divide that it has once created is not obliterated when the two sit on the same bench. More often than not, we have appellate courts carried by the senior judge almost without reference to the person sitting next to you. So you would rather have, as the senior appellate judge, a person who is the non-interfering type so that you can push your agenda and go through the cases fast. And so you have an appellate bench only by name which for all practical purposes and its functioning is just the wisdom or the sagacity of the senior judge on the bench. Which also takes me to the next aspect of this, which is we have a rule of seniority. Now, I will not get into the larger thing of the rule of seniority, but by and large, the judges, by dint of the number of years that they have been judges, irrespective of other considerations, get to head division benches. Now, that is not a more desirable way of having people manning division benches. It's just that the numbers are seen. The top 15 will head division benches. The next 15 will be single judges, and the bottom third will be sitting along with the top 15 on division benches. Again, this kind of a system requires some kind of change, and I wish, after your more important studies on other aspects are complete, these minor systemic issues which tend really to undermine the very, very basis of the justice delivery system is also looked into. Now, we've had some very enlightened comments in the morning, and I heard part of your speeches, and two further things, if I may just make a point on before, yielding to our speakers who have all the data and the analysis thereof. One thing is that, and I spoke to someone at the tea break, that we need to have more informed, more positive, and more aggressive criticism of judgments and the judicial work which is being done. The judiciary is not the judge's system. The judiciary is the country's system. And even if some of us have inflated egos where we think that we own the system, those inflated egos have to be put in place. And I invite, positive criticism on judgments, on issues, because one man or a team of 2 or a team of 3 or 5 cannot have their writ over issues which touch societies, or it is not possible always to coalesce all factors that ought to weigh in considering a particular matter. So if we have positive criticism, informed academic thought on matters, may be something which has come bona fide, but may not be ideal, can be revised, can be revisited and relooked at. And the other thing is that some kind of statistics, some kind of raw data without analysis has helped us take some ad hoc measures, categorizing certain matters, bunching certain matters. But at the end of the day, we really do not have all relevant material. One area, for instance, where I would recognize Professor Mohan Gopal's presence over here and the initiative that he put in, is that we would, in the judiciary, always shout that, we do not have the infrastructure, we do not have the wherewithal, we do not have the facilities to deliver. Yet, did we undertake any honest audit that based on the resources that we have, are we optimizing? Unless we conduct a self-audit or help those who are more adept at it come in and conduct an audit on our performance, on our functioning, how do we build a case that we need additional resources, more men, more infrastructure? We just make an arbitrary case, which is an anathema to what we are supposed to do. So these are the fundamental areas that I wanted to touch on. And one final aspect is that I think, and this is my perception and completely my own, that there is probably a lack of judicial philosophy or jurisprudential value in our decision-making process. We tend more often than not to be guided by our sense of what is right and wrong. We sometimes take recourse to our perception of the constitutional scheme of things and how it ought to be addressed without having the adequate legal background or theoretical basis for founding, the principles that we state. I think on that, I'd leave you to the more erudite and informed speeches of our speakers. Thank you.
I hope the numbers are visible. They may not be in the corner. Anyhow, I'll talk through them very quickly so that people have a sense of what I'm trying to say. So firstly, when I was asked to turn in a full-fledged paper 2 weeks ago, I didn't have one. I've got 3 or 4 different short pieces, so I wasn't really sure what I was going to talk about. But yesterday's discussions have really helped. And especially the presentations by Tasneem and Vikas, I think were potentially like path-breaking studies. Especially the last study, we couldn't really have a substantive discussion because of time constraints. So I hope to pick up on some of the questions which Vikas asked yesterday, and then try and weave that into our discussion here. So in the interest of limiting myself to 20 minutes, I'll try and answer 3 specific questions, and then of course, I'll do my usual tangential sort of references here and there. So the first bit in my presentation is just an explanation of this chart, which is just culled out from the Department of Justice numbers on the judge strength in the high courts. So I'll briefly focus on issues of vacancies and diversity on the bench. The second part of my presentation actually builds on a previous experience as a law clerk in the Supreme Court. So Arun, Nicholas, and myself, all 3 have incidentally been serving have served as law clerks in the past. So maybe it was a conscious decision to put us together. So maybe they'll also feed in more comments on that. And through that standpoint, I'll try to explain the institutional process of what exactly do we mean by disposal. I think that was the question asked in the morning, that when we assign numbers and we rely on numbers to make, let's say, predictions about what the court is doing, it's obviously a fallacy to assign the same weightage to each case without understanding what its context is, what is the subject category, what is the nature of the case, right? So obviously we can't get it, we don't have detailed data broken down by subject category, but we do have data broken down by the procedural filing types. So the famous story, of course, is there's this big SLP monster, and that's keeping the Supreme Court away from its main constitutional role. So of course that's the big story, but there are a couple of other smaller obstacles which we've encountered in our data, and that's one big reason why we've been sitting on it for almost 3 years, is that it doesn't allow us to offer strong conclusions about what the court has been doing. In the sense, we have the numbers now. We have 2 data sets. One is from 1993 to 2011, when the computerization happened under Justice Ahmadi. You did have a very strong classification system which was introduced. So we do have annual data sets for the last 18 years. And Nick has been consistently pursuing the NIC staff in the Supreme Court over the last few years to extract more data. We haven't gone the RTI route yet. But we also have smaller subsets. We have monthly statements on institution disposal and pendency from 2004 onwards. So I'll just quickly pick up one of those data sets and explain what we are trying to encounter. So in that sense, it's not just like raw analysis, it's actually the data we've got. So it doesn't reflect any secondary level of analysis. But in Nick's presentation, of course, he'll analyze this data across time. And he's working on, he has a working paper which tries to offer a theory about what these numbers mean for the court's social role and the perception of litigants, which are all broad themes that we've touched upon over the last few sessions. So if people can see the numbers, if not, I'll just keep blurting out the most important numbers. If you look at the aggregate number of, let's say, sanctioned posts, this is basically the Ministry of Law and Justice making this decision in consultation with the collegium at the moment. I mean, that's been the pattern since the late 90s. Earlier, of course, it was the Law Ministry indirectly controlled by Mrs. Gandhi, which would make all the decisions. But now we, of course, have a much more nuanced structure. So the number of sanctions positions, and I think the judges here can help me out on this, is not necessarily linked to population rates. Sometimes it's ad hoc factors like, let's say, spike in litigation in a particular state, but generally it is tied to litigation rates reported from particular states. Now the big problem, as Sudhir pointed out yesterday, is most of our data is collected from the Registrar Generals of the High Courts. So the quarterly court news which we get, which Vikas relied upon to offer his charts yesterday, is essentially just the tip of the iceberg. It's giving you the aggregate numbers of institution disposal and pendency after each quarter, and high courts are reporting on behalf of lower courts. So we don't have reliable data at the national level on, let's say, institution or pendency broken down by subject or broken down by bench performance is out of the question. I mean, even when we tried to ask the Supreme Court about, let's say, bench-wise division, they said you criticize the judges and we can't trust you kids. So that was quite difficult. But the idea is we really don't have that disaggregated data. So how we can get hold of that data is a separate question. Dr. Moily had announced plans for a national areas grid, which I thought was going to be perhaps create an online system where you could actually track cases by subject category and get a sense of it. But I think that plan has not gone anywhere in the last couple of years. So just briefly coming to this chart, and this chart is basically culled out from publicly available information. There's a Department of Justice which posts a frequent update on what's happening in the high courts. So obviously it's like a 40-page chart with a listing of each judge. It mentions on what date a judge was appointed, what was their parent high court, what are the transfers in a particular calendar year, what is their background. Incidentally, all the women judges are marked in red. So clearly, that's a priority, but I mean, I don't know whether it reinforces the sense of segregation or it's actually meant towards a progressive measure. So I've just culled that out. I mean, this is like a big picture overview. Of course, there's a lot more to this story. I mean, is caste and kinship playing a strong factor when the top 3 in the High Court recommend names which go to the Law Ministry, which then go to the top 5 in Delhi? Effectively, High Court appointments have these 3 levels of intermediaries. Of course, there might be more, and the judges can enlighten us on that. Because I mean, it's a very famously told story that all the judges essentially now know that the seniority norm has been consolidated. So you have to become a Chief Justice of a High Court if you have a standing chance of, let's say, becoming a Supreme Court judge. Abhinav Chandrachud put out an article last year in EPW where he's documented it from 85 to 2010. So it's like, it's a matter of fact. But the interesting bit in these numbers is out of the aggregate sanction strength of 895, 574 are sanctioned posts for permanent judges. So I think most people are familiar, but for those who might have, I mean, those who don't happen to belong to this rent-seeking profession, the idea is that when you appoint High Court judges, initially they are assigned as additional judges, and usually within the first 2 years they are made permanent. In some exceptional cases, you might have people being made permanent later. And recently, I think there were a couple of cases, I think in Allahabad, where there were graft charges and people weren't given a permanent status. But generally, most people are given a permanent status. But there is a classification which they maintain, both for the purpose of recording the number of sanctioned judges and the number of actual judges who are working. So the operative number for us is 627, which accounts for all the 21 high courts, right? I'll circulate this chart. So, I mean, if anyone wants to consult this or talk about it, we have everything on my pen drive here, so you can catch us. But so which obviously means we have a fairly high vacancy rate, 268 vacancies out of 895. So back of the napkin calculations, almost a 30% vacancy rate. And this is what is Vikas here? Oh, sorry. Oh, he's not here today. He would have enjoyed this. So a 30% vacancy rate in the high courts, which is your intermediate tier, obviously has an escalating impact on, let's say, areas in the lower courts. Now, I know yesterday there was a deep point of skepticism about supply-side solutions and why we must think beyond, let's say, appointing more judges. But let me just humbly submit that, look, when we have to talk to policymakers, we have to talk in terms which are accessible to them. So, of course, there is this complex anthropological data, and there is writings from the field of political philosophy, which can give you much deeper insights into how law and justice operates. But in the sense, if you want to push for tangible reform, it has to be reframed in a language which is more accessible to people who make decisions. So obviously, Justice Muralidharan said that in the morning, that how do you reconcile the shift in the language? And I've just started a small experiment at National Law School where I try to do a course on the legal system as a research-oriented seminar. I sent my reading list on the first day, and the enrollment went from 10 to 3. So the 3 people have been forced to come here. But hopefully next year I have a bigger group, and then I can use the bigger group to maybe put out more data out in the open. But that's a slight segue. So coming back to this data, if it's a 30% vacancy rate, what are the causes? And this is slightly speculative. Of course, I don't have access to correspondence between chief justices and the offers they make to senior lawyers in their respective high courts. We don't know who exactly has been considered. Anecdotally, we know that largely there are 2 reasons why this vacancy can be perhaps explained. Of course, I'm open to challenge on this, so please feel free to rip my assertions apart. So one is, of course, the opportunity cost story. That the people who have been considered for high court elevation generally are from the practicing bar, generally are people who've built up some experience or a reputation in that respective high court, right? And they will predominantly be preferred, especially when the top 3 in the court are making those choices. So at that age, when you're in your mid to late 40s, or in some cases in your early 50s, that's the prime range where high court appointments happen at the intermediate level. Why would you give up, let's say, a flourishing practice? Or even if you're not doing too well, maybe you want to wait it out and see, how you'll do when you're in your 60s. Or the idea that by committing to a career in the judiciary, you're foregoing an active career post-62, post-65. So it's an opportunity cost story. Of course, there are gradations to that argument that many people have entrenched local networks in a particular high court, so why would they move? They have family commitments or financial commitments. I mean, of course, it's wrong to paint it in a malified way. People might have strong reasons why they don't want to become judges. But generally, what the sense that we get is a lot of good people don't want to become judges because they have too much to lose. So that's a one speculative sort of theory which I'm putting out there. The second one, of course, is the inefficiency in the collegium appointment process, which Mr. Prashant Bhushan has been running a fairly active case in the press and in his statements over the last couple of years. And this, I think, he has a point. Apart from the Hobbesian argument about the collegium being this petty well of petty prejudices and personal lobbying and repeated visits to Delhi to convince one judge in the collegium, or people preferring their previous colleagues, or letting their old prestige-type rivalries have an impact on who to block and who not to appoint. I think that's the more sort of, media-friendly story. The actual story, I think, is in the efficiency of the process. So when you're processing High Court appointments, effectively you have 3 levels of consultation, right? The top 3 in the High Court, as I said, your law ministry, which is playing a coordinating role post the SCORA and third judge's case framework. They actually have a memorandum. So if people are interested, I can actually circulate the memorandum of appointment. And of course, then the top 5 in the Supreme Court, who take the final call. That's been the current pattern. So we clearly know that these 5 Supreme Court judges, apart from the 80 to 90 freshly instituted matters every week, have to write substantive judgments. And how much time can they actually devote to scrutinizing the record of a particular judge coming from the High Court, right? So even though they have a blind criteria, and because I was in the black hole of the RTI Act, I got a sense of the criteria. The black hole of the RTI Act being the CJL office. So the 5 criteria on which they use and which they haven't publicly declared is, of course, your disposal rate. Again, seriously problematic. If you're prioritizing performance in pure numbers, what does that mean? Second, number of decisions overturned. Number 3, of course, is the kind of complaints you might have got. And in this case, they don't pay too much attention to the letters which come into the Supreme Court. They pay more attention to complaints by fellow judges. So those seem to be the main criteria which are guiding the appointments at the moment. So my concern is, even if assuming that criteria is acceptable, I mean, of course, there are problems with that separately, but assuming that criteria is acceptable, how will these 5 actually monitor their process? I mean, the secretarial staff is perhaps 2 or 3 people who are keeping track of, High Court judges all over the country. So they have a detailed chart of how old is somebody, when were they appointed, what are their prospects, what are the feedback they're getting. Even if you were to expand that into a big bureaucracy, essentially it's a dossier on you, right? So on these 627 people, they have a dossier. But how will these 5 people make good decisions? I mean, I just don't understand. So I just want to look at that efficiency argument. I know it's a very narrow way of looking at the issue, but I think that is a big cause for why vacancies in the High Courts is also a problem. The story in the lower courts is, of course, far more complex, as we pointed out. It's got more to do with the fact that the exam process is longer. Considerations of quality often are important, and you really can't appoint people as, let's say, JMFCs or even the higher branch judges, because you're not satisfied with the candidate. So I think anyone who's been in the selection process will know exactly what's going on. So very quickly, because I take too much time in general. So very quickly, just to show you the other figures, 30% is the vacancy rate, but the more important bit is the disparity between the bar and the service background. So very quickly, people who get appointments straight from their practice in the bar, and people who are promoted from the lower courts. Now, generally, the popular wisdom has been, and I'm sorry, I mean, because I'm outside the system, of course, I can take pot shots. The stereotype is that lower court judges can't handle public law litigation, right? Or lower court judges are used to this passive style of judging where they let lawyers dominate, or they are bound by years of experience. So there are some stereotypes. Of course, it may vary depending on particular experience of particular lawyers in each part of the country. But there's a broad stereotype which used to be there. But the recent trend in appointments has actually belied that. It's the other way around. So if you look at recent appointments, so for example, let me just explain this. I don't have this on the chart. Out of the 627, 425 are from the directly picked up from the bar. 202 are from the service background. And the perception seems to be clearly changing, because when I broke the information down as to how many service judges have been appointed in recent years, since 2008, more than 100 judges from the service background have been appointed, which means there's been a clear shift in thinking that older prejudice against judges from a service background seems to be dissolving. Now, whether it's happening at the level of people who make decisions about appointments, or is it a broader feedback from the bar, we don't know. But it's clearly something which is happening. In the last 4 years, I put the numbers together, and if we include the number of judges who've been directly elevated from the service background to permanent judges, the number actually comes to around 110 out of 202. So 110 newer judges appointed in the last 3 to 4 years have all come from the service background. So we clearly see a shift in thinking, which at least the numbers show. Of course, what the speculative reasons behind it are, I might be entirely wrong, but at least we see this clear shift that more people from the lower judiciary are getting promoted, especially the last 3 to 4 years. Now, whether it has something to do with, let's say, the decision which is discussions which happen amongst the High Court Chief Justices or the collegium is a separate story. So very quickly, before coming to that story, representation of women, of course, is fairly less, 51 judges out of 627. I've also just tracked, and this is the intersecting category of judges from outside the state. So they have a policy of having a chief justice from outside the state. These numbers are from December. So of course, some errors, some numbers might have changed over the last 5 months. So again, about 51 judges from outside the states, normally the chief justice, and of course you have some people who voluntarily take transfers, and you have other stories. Can we go to the second table? Yeah, so if this is the disposal rate of High Court judges based on and classified by their background. Now the problem with this data at least is that it's only for 1 year. And I think Dr. Mohan Gopal might have already seen this 4 years ago because this was part of a document circulated in the Chief Justice's conference in 2009. And I think there's been no such conference after that, or has there been? Oh, it happens every year, so it's just that I didn't have the updated data. So if you look at that consultation, of course somebody was interested in this question. That, how are we assessing the performance of people from a service background and who come directly from the bar? So clearly there was a conscious decision to think about how we can use this existing pool of people who are already available to you. So if there's a problem of, let's say, there's an apprehension about how many people can move up, there was an assessment of disposal rate. So of course, numbers are problematic. As was pointed out, numbers themselves don't capture the actual amount of work involved in the case or the amount of preparation it requires. And that will be a segue into my Supreme Court discussion very quickly. So, but these numbers just show you very clear trends. So in 9 high courts, of course, you had the older prejudice or the popular belief. I mean, again, it may not be popular anymore, but it comes out very clearly where you have judges appointed from the bar who have significantly higher disposal rates. It's Allahabad, Bombay, Chhattisgarh, Himachal Pradesh, Karnataka, MP, Madras, Odisha, Patna. 4 high courts where the difference is not much. And 6 high courts where judges who come from the service background are doing better in terms of disposal rates. Of course, the big caveat being that higher disposal rates are not necessarily indicative of improvements in the quality of decisions. Or furthermore, the evidence is not conclusive because it does not account for the relative ease or difficulty of disposing of different subject categories or cases which might have arisen under newer statutes. So if you get into the discussion paper on judicial impact assessment, which was published a few months ago, clearly, can I just take a few more minutes? I mean, this is probably the first time we're presenting this, so. Yeah. So very quickly, the evidence in terms of numbers is inconclusive, right? So clearly, we have more people being elevated from the service background in the last 4 years. Since 2008, there's a clear statistical trend. If you look at the chart, almost all the additional judges are from a service background in many states. So clearly, there's been some thinking about this amongst the judges, and that is playing a role. And then we can't even make claims about performance, right? So the popular prejudice of a lower court judge not being able to handle public law litigation is probably now demolished, right? There are many service judges who have done exceptionally well and are actually now in the higher ranks as well. So the last chart I just want to show in this set is the lower court's vacancy. I think that is publicly accessible. Can we just go to the third table? Yeah, it's already there. So right, I mean, this is available in your court news, so it's not very hard to find. It's just your aggregate number. So 18,008 is your aggregate sanctioned strength, and 14,374 is your working strength. So which means still there's a vacancy rate of about 20%. And I think this deserves deeper scrutiny. Are there things you can do with the selection process in the lower branch or the higher branch? Is the existing model of the public service commissions and high court judges together selecting judges, is it working, is it efficient, is it taking too much time? I think that could be the subject of a separate study. So hopefully in the next few months I'll be able to collect some information to substantiate this part of the claim. So now can we just go to the Supreme Court file and then I'll hand it over to Nick. It's the monthly statement, yeah. So this is, I know the data will probably not be visible. So this is basically the building block of the data we have. And this, I'm jumping from the previous topic to the next topic. It will be a segue into what Nick wants to say, is that we have monthly data broken down from 2004 onwards, and we have annual data which consolidates this from 1993 onwards. So if you look at the classification, the reporting of institution at the admission stage, which is your miscellaneous matters heard on Mondays and Fridays, that's the first set. The regular hearing is on the second page, so I'll quickly come to that. Is classified by procedural categories. So of course, special leave petitions, civil and criminal, are a disproportionate part of the docket, right? It's almost like 27,000 odd cases out of a total which comes in the next page. So you've expanded the text, right? So clearly almost a 70% of the inflow in the Supreme Court is coming through special leave petitions. There's a deeper story there. Is it a chicken and egg problem? Was the court admitting too many SLPs in the 80s? Have lawyers internalized the habit of filing SLPs as a last remedy? Or is it that more parties now are capable of going for another round of litigation? So there are more complex stories to be told there. And unless you do a sort of ethnographic study, consulting, let's say, people who practice or file, most importantly the AORs who are essentially the intermediaries in the Supreme Court, you really can't answer this question conclusively as to why is it that the Supreme Court is spending far too much time on SLPs. I know from the viewpoint of how judges allocate their time, this does take far more of their time. Every week, and of course my sample set is limited to the judge I work with, but the discussions I've had with other people who've been assistants has been that nearly the bulk of the week is spent in preparing for your admission matters on Monday and Friday. Some judges have different styles. Some judges let the lawyers argue in court and then they make up their minds. Other judges who have already been thorough with the files will probably already have an opinion, and the lawyers won't really have much of a say when the arguments come to court. So those are the structural sort of issues which arise. Another obvious problem is, if you can just go back to the first page, and this is what I wanted to flag based on the morning's discussion. If you look at the recording of how cases are disposed, of course we have an aggregate number of cases which are disposed. But this chart breaks down at what stage they are being dismissed. So in limine is what Justice Muridhar was saying. When you simply say petition dismissed, right? Irrespective of what is said in court, you have a two-word order saying petition dismissed. After notice is usually cases, I mean, of course there are exceptions, usually cases involving the government, where some government body is given a notice to come up with a reply or additional submissions, and essentially you will have more than a couple of hearings. Adjourned is, of course, when you have multiple hearings on miscellaneous days, so there is a clear progression. You might have, especially in continuing mandamus cases, where you have, let's say, additional writs being filed. Of course, interlocutory applications, don't show up in this. You have additional writs being filed, which will actually complicate the picture much further, but that's what shows up under adjourned. And the problematic category for us is actually leave granted. So leave granted and disposed of is when the judge has heard brief arguments in the court and a short order is given, let's say, a couple of days later, or the matter is converted to a regular appeal, but you don't have the matter progressing to regular hearing, which is, it's not scheduled for a Tuesday, Wednesday, Thursday substantive hearing. So that is your category called leave granted and disposed of. That we understood. But the big flaw, which is kind of obstructing our further analysis, is that if you want to offer an actual accurate rate as to how many cases are progressing from admission to regular hearing, because a lot of lawyers would be interested in that. We had a preliminary figure of 12%. Actually, Nicholas had it. He published it in a magazine piece 3 years ago. But clearly, the premise behind that is slightly flawed, which we realized within a few months of that piece, is that the number of leave-granted cases which are coming into the court don't tally with the number of regular hearing cases which are showing up in the court's own records. So we're not even talking about a distant, like a Tehsil court or a district court, right? We're talking about data compiled by the Supreme Court. The aggregate numbers are published as part of your quarterly reports, your annual reports, and that's the data which has been built up over the last 60 odd years, and we rely on that. The last page in the data set is the aggregate number which you see publicly reported. But if you look at this data set, clearly the number of leave-granted matters which progress to regular hearing. I'll just quickly show the next slide and I'll end. Yeah, this is the regular hearing chart. So clearly you see a disparity between the number of regular hearing cases which are showing up as registered during the month and the number of cases which were granted leave. So of course at this stage, like, SLPs are almost negligible. It will mostly be civil appeals or criminal appeals because it's been converted to a substantive question, but there is a disparity. And to be honest, like, we were scratching our head about it for a couple of years, and the most recent discovery is that they have acknowledged their error, that the data set, at least what they gave to us, is erroneous. And there is a mismatch between the number of cases which show up under leave granted and the number of cases which show up as registered under regular hearing. Of course, they account for, let's say, preparation of cases and time lag on account of, let's say, filing-related issues. There's a separate category for cases which have filing defects. They show up as unregistered. They're essentially processed by the registrar's courts. So we are far, far away from theorizing the court. I mean, we seem to have this data, which looked very promising, and we had lots of ideas about it. And Nick has actually extrapolated some analysis from that, which we'll move on to now. Right? Yeah.
And just to follow up on this point, are you back on the, if you can go back to the first page.
The admission matters.
Yeah, this unregistered, registered. Because one of the things that had confused me for the longest time, and I felt bad intellectually later, it's because for a couple of years I was putting out this data about, this is how many cases that the Supreme Court is disposing, how many matters it's disposing, and I was basing that off the annual report numbers. But the annual report numbers are based off of these monthly statements. And one of the biggest that has been tallied around all through this conference is about the number of admission matters it actually disposes of. And they get that from this first monthly statement. The problem is, you'll see this unregistered, and if you go to the, can you just make this all one page?
And it was.
Yeah, just the, yeah. So if you see this unregistered, registered matters, right? If you add this up, it comes out to about 20,000 matters a year. Those are not matters that are, essentially the court is double counting, right? So those are matters that are going to the registrar. There's some filing defect with the matter, right? Given back to the litigant, they fix that, that filing defect, turn it back in, and that's counted as a disposal, right? And this is something, actually Justice Sinha pointed me onto this initially. And it's something that most judges, I can tell you most judges on the Supreme Court don't know this. and they just look at this and they just count on the annual report numbers coming through. And this actually throws off the numbers of how many disposals each judge is doing by considerable amount, because it accounts for about 20,000 cases a year. But just the fact that it took a conversation with Justice Sinha and then multiple conversations with the Supreme Court and the Registrar and the NIC to try to get this out and finally to understand that otherwise these numbers just don't add up, right? And that's a problem, and they're going back into their computer software and they're trying to fix the numbers now, and I give them a lot of credit for saying, okay, we have this issue and we're gonna try to resolve it and figure out how we can, have a better set of numbers, but that's going to, and we'll point a number of other anomalies, if you can go to the PowerPoint now, that have come up as we've gone through, some of which I don't think we'll ever answer, because some of it comes from the 50s and the 60s and the 70s, and we have these anomalies in the numbers and we just can't find anybody to talk to try to kind of get to the bottom of this issue. Yeah, understanding our court. When you talk about the Supreme Court of India, I think it's almost impossible to understand it as a court and as an institution without thinking about it statistically, right? This is a court that has had almost 1.3 million cases come before it. 2.7 lakh regular cases have been heard and decided. And, there's some people in the US who pride themselves on having read every single US Supreme Court judgment, which actually isn't too hard to do because the court just isn't producing that, produces 80 judgments a year. You can keep up with that. That's, plausible reading. You can't do that with the Indian Supreme Court. And I think because of that, there's no one judge in that institution who can keep track of the whole thing without at least understanding it in some way through statistics. And a lot of my interactions with the court, with the judges, with the bureaucracy have made me think about, there's this political scientist called Jim Scott, who a lot of you have probably come across. He has a book called Seeing Like a State. And he talks about this idea of legibility and how the state tries to make citizens legible by giving them data cards, identity cards, all that sort of thing, doing censuses. But when I'm around the bureaucracy and when I'm around the judicial system, I have this thought that the Supreme Court, the judicial system, is trying to make itself legible to its own self, right? It doesn't know what's going on out there, below it, within it, around it, what even individual actors in it are really doing. And so it's this struggle to define legibility. And I think, as we're going to point out, a lot of these numbers are wrong. There's big problems with these numbers. But I think the first step is just get them out, right? Try to figure out where all the challenges are, and then work with the system to try to get good, solid numbers going forward. So I'm just going to run through this, and I'm going to run through some of the interesting things I think you can do once you get better numbers. And you can even tell, even in the last, I think the numbers have gotten better in the last few years, or at least we can describe them better because we know the actors who put them into the system. So this is a chart that looks very much like one that was shown yesterday by Vakash. Just a couple of things. So this is the admission, the blue and the yellow. Right, so these are admission matters being instituted is the blue, disposal is yellow, so that's admission day. Down here on the bottom is regular hearing, right, so there's far fewer regular hearing matters. And then you have this pendency of both admission and regular hearing matters. There's a couple things we've been able to figure out about this. So one, as Vakash mentioned yesterday, part of this is how this drop-off, right, in pendency is in part explained by how they kept, how you keep track of aggregated matters, right?
It was the hyphenation change.
Yeah, the hyphenation change, right? In terms of you have a number of matters that are all being heard together. There's 20 matters being heard in the same case, one judgment, right? That is now being counted as one, right? And so before you had 20 pending, now you have one pending. That's the drop-off. But that's not all of it. And you can see that even in there's a difference between the disposal and the admission. And so the story we were told, others in this room probably know this better, was that in the early 1990s, they brought in district court judges to actually go through the Supreme Court matters, collate them, put them all together in kind of different areas, in different clumpings that made sense, and then disposed of them in that way. So we can account for some of these spikes. Some of the other spikes we can't really account for, right? And I'd love to hear if people have theories. And Vakash, I won't go through this again because Vakash brought some of it up, but we don't know an explanation for some of these other spikes in this chart. Okay. SLP story. So I started off, one of the other data sets we had were monthly statements from 1971 to 1993 because of Rajiv Dhawan, and luckily there's somebody out there, because interestingly enough, the court doesn't seem to, it's unclear if they have all the statistics from themselves. They might have misplaced some of the statistics that these monthly statements from back in the 70s and 80s. It's in there somewhere, maybe not, right? So it's very hard to go back into them, but Rajiv Dhawan had kept track of a lot of this. So he has them from 71 to 93. So you can see this is the percent of SLP, right? Starting out around 91% of matters were SLP, which is pretty high, right? And the SLP has been there for quite a while. And we can have a conversation about the SLP, but I don't know if I have as many issues with the SLP. Then you can see writs are getting much more popular during 75, 80, 85. That's why the SLP is going down, because writ petitions are going up. These are the other numbers on SLP. This is civil criminal background. How many are civil, how many are criminal? You can see there's fluctuations. I don't know why. Maybe somebody else knows why. But our idea is let's get them out eventually and somebody can start explaining why or why not they're there. Next page. This is petition types that are not SLP, right, since 1993. You can see one thing is there's this, the blue is the writ. So there's a drop off on the writ. Today, the writ petition is less than 2% of cases that are coming into the Supreme Court. It's really not a story anymore. Sometimes it's high profile cases. Part of this has to do with, I think there were some judgments in the early 90s which said if you can file a writ petition in the high court, go there, don't bother the Supreme Court anymore. So you see this drop off. I won't get into the others, there's too many slides. So. This is years of backlog. This is one way one could calculate years of backlog. All this chart is showing is how long at the existing, the rate of disposal that the court currently has, would it take them to get through their pending, their current backlog, right? So it's just a simple division, and then you can come up with a rough estimate of the year's backlog. But there's a lot of problems with that methodology. I won't get into it, but at least it shows you kind of one thing you can do. There's all these sorts of spikes, again, during eras where we don't have as many people to talk to, that we don't have great explanations for.
You have a large number of IAs in the PIS. Each IA is a substantive petition.
And it's not counted in this.
Yeah, so the IAs, that's something that's going to come, because earlier the court actually kept track of miscellaneous. It was a separate, which included the IAs, and it was a separate thing, and they stopped in the 80s sometime.
Stopped in 89.
Okay.
It's included within the writ petition knowledge. So an IA would be actually a disposal because it substantively decide issues, and then there might even be a judgment in an IA.
Yeah, so, okay. Yeah, and I think that part of the thing that we want to start at the end of this, and also in discussions with others, is what should the court be keeping track of, right? Because it's kept track of different things at different periods of its history. In some ways it's improved. We'll get to subject categories, which we can't find from earlier periods as much. So it has more definitions in some ways, less definition in others. The ranking committee report, right? If you go back to 1925, one thing they kept track of, which would be very helpful, is how many cases are actually decided. How many are settled out of court and then brought in, and the judge is just essentially. Yeah, so we have judgments delivered, and I'll get to that in a second. But that.
Review issues is one category.
Yeah, so review is that's included in the group. If you go back to the slide before, sorry. Yeah, that's this one.
So it has been going up. See, there was a curative petition introduced, and that shot up the reviews.
Oh. You know this, okay. Okay, go ahead. So then this one. So this is another way to keep track of, backlog, which is how the Supreme Court does. And we didn't get to all the pages in the monthly statement, but essentially they show for both admissions and regular hearing when they were filed, if they were filed in 2005, 2006, 2007, 2008. So I just kind of aggregated that. So how many of the admissions filed were in the last 2 years? So in 2004, 93% of the cases were in the last 2 years, 71% had been filed in the last year. Strangely, and I don't know if people at the court will agree with this or not, but it seems like the court's been getting worse, right? 67% were filed in the last 2 years, and 44% in the last 1 year. So before, most of the cases that were waiting were new cases, right? 71% were in the last year, so they were new cases. Now, in 2010, 44% were filed in last year, which means 66% are over a year old, right? When before, only about 29% were over a year old. And yet, I hear from, the registrar was trying to tell me that now admission cases get heard much faster. And I don't know if that's the experience with lawyers or not, but this is what the Supreme Court's official numbers are. I'm not saying anything.
There was an important change where the turnaround time.
Yeah.
See, the notice was issued this change happened about 3-4 years ago. Yeah.
2004, 2005.
And it didn't come back to the court till service was complete and pleadings were complete. So which meant that actually it would slow down the disposal of the SLP. So what could be happening is the first hearing dismissals are going up.
I see. I'm just going to keep on looking over to make sure that all this is either he knows already or we're writing down.
Actually, we have a serious problem with the second hearing of an SLP being postponed by more than a year.
Okay, and so that's what this is picking up.
Yes, and that's a huge issue because
Okay.
you just lost after a notice is issued.
But shouldn't that coincide with the unregistered cases? Because
No,
that
no,
attracts,
there's another issue which you will have to go into, which is the increasing tendency of the Supreme Court to pick up cases and decide at the SLP stage, which has increased, and you will find there are two numberings happening. The very first paragraph or the very last line would say, leave granted. So you would have SLP disposal and simultaneously a civil appeal being registered and disposed.
Right.
so in the disposal chart,
So you will have to factor that in.
Yeah, and I think it's supposed to
And
be.
it is also important on the, it impacts on the pendency because
does.
you are taking that much time to address this particular case and you are not able to reach out to the older case.
No.
There are several cases where actually substantive relief is given, where it's not even admitted. Notice is not issued, but they just carry on discussing what to do, and they may do something corrective, and then they actually withdraw.
Of course, the quickest is when it is disposed of at the mentioning stage.
Right, and which is what lawyers increasingly, I think, want to do, or maybe they've always tried to do, I don't know. And that is that leave granted and disposed category. But one of the things that does it, then it throws off all the rest of the statistics, because those cases never make it to regular hearing, but you could consider them kind of like a regular hearing judgment. So if you're trying to conceptualize what is the court actually doing, well, a lot of it doesn't make it over to this side, right, to the regular hearing side. And yet we don't know, some of those leave granted and disposal might not have been much of a consideration at all and aren't worth counting. And so it's another problem that kind of enters the numbers. And also when we try to figure out, and lawyers are particularly interested in this, like how many are accepted, right? How many matters are accepted? How many matters do you actually get the court's attention? They hear it, they're going to decide. Well, if some of those are leave granted and disposed, we don't know how to come up with a percent anymore, right?
And
Because
we treat the PIL cases very differently because they keep coming for monitoring and for
Right.
directions and
No,
all
I
this.
think that's right.
The danger in all this is that we'll end up in a Philippines kind of situation where the Supreme Court said we are going to put limits on how many cases you can file because the whole thing becomes quantitative rather than qualitative.
Yeah, no, and I think we're,
We go in a completely different direction.
yeah.
So in a sense we have to be very careful.
Yeah, so I'm going to,
Not to generate the kind of data that will end up shifting the whole debate to a very different direction.
yeah.
And into this, to some extent, the US also, I think, in the time of Warren a lot of changes were brought in, which also emphasized a lot on the numbers, and that's when this number of filings actually went down, number of cases admitted. Rehnquist was later, but it started.
No, you have Taft and, so the 1925 Judicial Act, anyway.
So he started.
So I'll get to that at the end, because I do think there is a cautionary note at the end, but right now I just want to say what's out there, what you can and can't say about it, and that I don't think it's good that there's errors in data, right? I think we can all agree that,
You're
yeah.
not supposed to add a factor. You're counting things that really is not supposed to add.
I think we should just
Yeah.
finish and start.
And then we can, yeah. Okay, so this is percent of admission. This is the disposal of admission matters by subject category. So this just gives you a sense of on admission day, what are the types of matters that the court is actually dealing with, right? And so you'll see criminal matters of the highest, ordinary civil matters, what you kind of expect. I'll just let you, so this is average out over from 05 to 011, gives you just some sense, what is the Supreme Court doing with its time, right? Well, maybe not its time, we'll get to that, but what kind of matters is it dealing with that are coming in? One of the issues with this subject category, as I understand it, is that the lawyers pick, there's a list of 40-some categories, and they're picking which category to put it under. So, and many cases might fall under, you could argue would fall under more than one category, maybe there's an error in categorization. Hopefully over time that kind of evens out if you're just concerned about the broader kind of statistical picture. Next. This is the same, but by regular hearing. What are they disposing of on the regular hearing side, right? And I'll just give you a second to look, but it's very similar. I don't need to talk through, and we can get this chart out. Okay, next page. This is again, this percent accepted, all of this comes up with is from flawed numbers, essentially looking how many make it, from how many disposals of there are admission in any given year, compared to how many institution of regular hearing matters, right? And that's going to give you a problem number for a couple of the reasons we were talking about, but this is over time, so at least gives you some time. But we know, look at this, like back in the 60s, it's over 100%. Somehow, I have no idea how, but this is in the annual report, I just take the numbers from the annual report, that there were more matters being instituted on the regular side than were being disposed of on the admission side. This might be because the Supreme Court is now structured differently, something else is happening, but this is just what the numbers say. I have no explanation, but we can get to that later maybe. Next. Acceptance rates. So this is, again, I just calculated the acceptance rates in the same way by subject matter. So looking at how many were disposed of on the admission stage by in any given subject matter, and then how many were instituted on the regular hearing side. Again, that's going to give you a very rough number. I don't have all the data for 8, 9, 10 to be able to do that, unfortunately, kind of waiting for some of those numbers. But it gives you some sense, well, what kind of roughly, what's making it more from the admission side to the regular hearing side. So certainly these requests for 3 and 5 judge benches, the direct tax matters, arbitration, land acquisition. So labor, service, a lot of kind of business matters are above the average. This is the average, right, at 12% or so. And then criminal matters, family law matters, personal matters, compensation matters are a bit below the average. We can think about different reasons that might be. Yeah, I feel like I'm, maybe at the end, yeah. But all these subject categories I'm showing all subject categories that had over 1% of the court's time. So these add up to about 92% of the court's work. There's a lot of other like maritime law and, you know, these little subject categories that not much is happening in.
And the large bench cases are classified as separate subjects.
You use these terminologies from the Supreme Court's own giving out stats.
Yeah, all I'm doing is just saying what the Supreme Court gave me and told me. I'm not like making anything up. I'm literally just kind of, I'm parroting back what I was told. Yeah. So the monthly statement list. There's 46 categories, all of which are these. I'm just cutting and pasting them over. I'm not doing anything.
On a lighter note, the Supreme Court says everything matters.
This is just another way of figuring out the age of the regular hearing matters, right? This is by subject category. So you'll see, interestingly, although more tax, indirect tax, arbitration, business matters are accepted at a higher percent, they actually stay around in court longer. So they seem to be backlogged more. So this is one way to try to figure out what is the Supreme Court prioritizing. And it's good. It seems like, you know, criminal matters, family law matters are getting prioritized. They're not sitting around as long. And we know that the court is making a conscious effort to prioritize family law matters. So it's good it shows up in the numbers. And this isn't, you know, just something that the court says it's doing. Thank you. Okay. Next page. I won't get into this too much, but this is appeal rates by high court. Again, they keep track of how many cases are coming from each high court. One thing you can show by looking at how many disposals there are from each high court is then calculate what percent of those disposals from the high court are getting appealed up to the Supreme Court. There's lots of problems with these numbers. One thing that kind of comes out in the numbers, though, is Delhi's the highest, which makes a lot of sense. People just go down the street, appeal. Probably some lawyers in this room do that. And then we don't have enough time to get into other ideas behind it. Other things, so this is the first, if you go into Judas or Indian Canoe, look at how many judgments there are compared to how many reported disposals of regular hearing matters there are. This is what you'll get over time, right? So clearly there's a far less judgment. So there's a lot of reasons to think why that might be, but it gives you some sense about what's going on. I'll go back. This one right here is something that a lot of people have been concerned with. This is just off statistics actually that I and a bunch of students had brought together, was looking at 5 judge benches over time, right? So this is the number of 5-judge benches in any given decade. There were over 100 5-judge benches a year in 1960 to 64. By the time you get to 05, 09, you're about to 6.4 5-judge benches a year, right? So there's clear, this whole lamenting of the decline of the 5-judge bench, it's happening. We can say if that's a good or a bad thing. We can have a discussion about that. But this clearly shows it's happening.
No,
Next page. And I know I'm over time, but
constitutions.
yeah.
3-judge benches. That might be interesting.
Compared over time. That's good. Okay, I'm just going to really rush through. I know I'm way over, but I'm going to. So, I mean, one thing to think about is the court in crisis. There's been almost a doubling of the number of matters getting appealed to it over the last 10 years, but there hasn't been a doubling in the number of matters that it's actually been hearing for regular hearing. So is it in crisis? How do we even define whether it's in crisis? That's something we want to define statistically. What statistical numbers would help us with that? Do we want to figure out controlling the flow? If it's been holding on the matrix I had used at about 12% acceptance rate. Is that the rate you want or not? There's been a lot of ideas floated out about, we need a dedicated constitution bench because these big constitutional issues just aren't even matching up. The Constitution says they need to be heard by 5 judges. They're not being heard by 5 judges. Is that a problem? We can talk about strengthening the high courts, improving the data, which is obvious at this point. I wanted to get to this point, though, which is what is the identity that we want the Indian Supreme Court to have? Because I think this addresses a little bit of what you are talking about. I got into the numbers, not even particularly because I'm that interested in numbers, right? I'm not a statistician. I have no math training. I have no science training. I have no economics training. The only reason was I was a clerk at the court. I saw all these numbers. I saw that no one was talking in the framework of numbers. Everything was anecdotes around me, right? Whenever I asked a question, you just get another anecdote and another anecdote. And then suddenly I saw these numbers going, through the office, and I asked, is it okay if I take these and, make some of them public? They agreed to that. And so I thought, okay, that's nice. And then no one, it's been very slow for other people to kind of join in this and at least making this public. And I always think, this is one very useful way, I feel, to make a system legible. I think there's deep concerns about we don't want it to be, if Keshav Bharati is being heard, well, maybe you should hear one case in 6 months, right? And that's okay. You don't want to hear 200 cases in 6 months. But what is that identity that the court wants to be? What are the values that are at stake? Is it a story, right? And I do want to emphasize I'm not saying anything but that it's just a very small sliver of the story. And I think I'll skip the last slide, which you can flip to, which was just about some further work that I think needs to get done. And a lot of it seems intuitive at this point, but I want to make sure I don't keep you from speaking and people from their lunch later on.
Thank you. I don't know about the rest of you, but the last 40 minutes, my blood pressure has sort of gone up. There's been a lot of interchange. There's been a lot of numbers. It reminds me that I've been out of the Supreme Court sort of culture for more than a decade, and I'm not used to the pace. And I also want to make sure that the people in the room who are not Supreme Court lawyers and intuitively know the difference between SLPs and regular matters are also part of the conversation. So I'm going to try and just slow down a little bit and put things in perspective, sort of link it all back to the themes that have come up earlier. I do want to start by saying, I'll talk a little bit about what I'm going to say, but before I do that, this is not just by way of formality, but thank Sudhir and his excellent team, Manavi, Leah, Dolashri, everybody who's been involved in this conference. It's as having organized as an academic conferences, you realize the challenges of trying to pull things together, get people, the logistics involved. I was struck yesterday we had 2 presentations by Skype and other forms of technology where it was 3:30 a.m. for Mrinal and about 6:30 for Sheetal. So it takes a lot of things to sort of pull this together, and that's quite remarkable. And I think we've had a very energetic and stimulating 2 days of thinking about this. And I just want to acknowledge that this has really been very, very stimulating. I don't know if my experience is similar to some of yours. There's a lot of stuff that's happened. We've talked about a lot of ideas, and it'll take time to sort of process that and think how that's going to be done. And I think Sudhir and his team will have to sort of transcribe some of this, circulate papers, and see where to sort of take it. But I do want to say also the law and governance, the LGDI, as you're calling it, the initiative, One of the things that we've seen presentations by Manavi and Vikas and Tasneem, and hopefully the work that has been done by other people will also be made available to, I guess, a larger set of people, and we can talk about that, because if we just look at the schedule for the 2 days, the number of issues we are covering is pretty phenomenal, and trying to keep track of it. Obviously, different considerations come up for different sessions, and how do we sort of process all of that? I mean, we're talking about legal systemic reform, which is a huge sort of task. I think, so this session shows that if you get a group of judges, lawyers, and academics who know the Supreme Court system, so many questions come up, and the clarifications that are coming up, it's quite something to sort of process. So I do want to say, so in the initiative note, Sudhir mentions that law and development as a subject is not really taught that much in law schools. And I'm going to take your word for it, and I'm sort of thinking of my own journey as a law student. One of the good things, I guess, about having a monopolized, centralized system of curriculum through the Bar Council is we had sort of courses on law, poverty, and development, which were compulsory. And that tradition was kept up. There were people who would sort of teach it as part of others, and there were some people who sort of focused on it. I remember Arun was involved in a course on law and development in I think, 99 or 2000. And coming back from Warwick, which also has a whole program on law and development, bringing in some of those readings and then sort of taking it forward. I think when Dr. Gopal was at NLS also, there was a course on law and development. And so what I'm going to do in my sort of remarks is try and talk about the field of law and development in a sort of general sense, and there's a lot happening in the field. And then perhaps to link up to the panel, come back to reforms. And I'm not sure why, I think Sidharth and Nick, being diplomatic, haven't really pushed their ideas of reform forward. I suppose I have the advantage of being completely out of the system and out of the country as well. So I think I can be more forthright in saying we need to tackle some things. And maybe there's a historical basis for it, and we can try and understand that. So I'm conscious that we want to have a discussion, and the discussions have been great, so I'll try not to take up too much time. So when Sudhir first said that there's going to be this conference, I just finished, so earlier this year, there's a book published by Routledge called Law and Development in Asia. And the question that the people who were called for that conference were asking is, how do you respond to things like legal and judicial reform within Asia? And then the larger question they had was, is there something about Asia and the fact that there are many developing societies, there are societies which have developed quite rapidly, which allows you to talk about law and development issues in a distinctive way? So the book has been published earlier this year. I contributed a chapter to it along with a colleague from Singapore, Michael Ewing Chow. So for the first part of my presentation, I'm going to give you a very little sort of summary of what that chapter was trying to do. And in the second part, probably address the topic of the panel, which is reforming the court. So the chapter is, I think I've sent it on to Sudhir, and when the papers are circulated, that will be there. But I just wanted to sort of flag some things and give some context. So I take, in the earlier session, Justice Muralidhar had sort of cautioned that one has to be careful when one is doing comparative sort of study. And clearly India is a hugely exceptional society in many ways. But then I suppose my response would be to point to Justice Muralidhar's scholarly work himself, and in your book on legal aid, by looking at South Africa, looking at other places across South Asia, one is very cognizant that our context is different. But surely one can look for insights, and even the way others have approached it, have put together systems for that. And I suppose that's the impulse for the chapter that we ended up writing. So that chapter has a specific context. In 2007, there's a report published by the World Bank by someone called Walid Haider Malik, who the title of the report is Judiciary-Led Reforms in Singapore, and Frameworks, Strategies, and Lessons. So this is an official World Bank publication. In its foreword, 3 officials of the bank sort of recommend this as perhaps a model for other societies. Right? My colleague and I were puzzled by the approach of the report towards Singapore, and also to its possible comparative sort of application. So, and given my own background in Indian law and my colleagues in Singapore, we sort of were trying to critique that report and say, assess it. What are its implications? How does one understand it? And because in the foreword, the World Bank officials sort of made this claim that other societies in Asia should perhaps look at this report. There was also a potential for comparative application. So what the chapter does is basically say, well, what can we learn from this report, and how do we apply it to a society like India, and what insights can we perhaps draw from that? In the end, we concluded, not surprisingly, I mean, given the problems of scale, right? So Singapore is a society whose official population is about 5.2 million. And how much can you apply that to a much larger society? There were going to be problems. So not surprisingly, we said one has to be careful, local context matters, and that's sort of important to bear in mind. But nevertheless, we did say that there are interesting implications of looking at other systems, and one should sort of look at it. So I'll give you some examples. So we've been talking about pendency and where it's going. So what the report, the Malik report, points out is it covers the tenure of one Chief Justice in Singapore from 1990 to 2006. In 1990, the Singapore legal system, which has a lot of similarities with India. It's also a former British colony. The Constitution of Singapore actually is textually very similar to the Indian Constitution because it was inspired in part. There was an Indian and a Pakistani involved in drafting the Constitution, which is currently the Constitution of Singapore. So there are similarities, and it makes sense to sort of compare these societies in some ways. So in 1990, the rhetoric in Singapore, in a small society which is very much committed to efficiency, was that the courts are inefficient. Right, so in 1990, the Malik report sort of sets out these statistics. It took an average of 6 years to finish a case in the Singapore legal, in the judicial system. Capital punishment cases, which are a big part of the Singapore justice system, and equally in India as well, took about 4 years to complete. They appointed a Chief Justice who had been a banker for the last 20 years, and in some ways it's a good choice because he basically came in and said there's an input-output problem, about streamlining it, managing it, and by the end of his tenure, by 2005, those numbers had changed quite drastically. So by 2005, it took 7 months for a case to finish, from start to finish, in the judicial system, and 6 months was the average sort of time. Right? Including, yeah, so for a while, this is Chief Justice Yang Peng Hao, and you're familiar with him, and even, so he took pride also, before he was sort of corrected, and so maybe one should not take pride in having a very efficient system for the death penalty also. So, but that's been and that's why the Malik Committee report sort of says, let's study what has been done here, and perhaps one can study it there. And if you look at the report, it has a sort of step-by-step, 7 steps to sort of follow, lessons to take, and all of them are steps which are quite familiar to people who've looked at the Rankin Commission onwards, the various Law Commission reports. And they're not, there are some there which are very specific to Singapore. It's about leadership skills and having Chief Justices with long tenures. So Chief Justice Yang Peng Hao was in office for about 16 years, and his ability to sort of see his vision through also sort of mattered. And we know for all kinds of reasons that's not going to happen in India. So one of the things to sort of consider is, and Singapore has a pretty low crime rate, it has a very high conviction rate. The reforms in the criminal justice system particularly were quite spectacularly successful. Right, so but when we sort of talked about this, we said there's a law and development literature, and there's a fairly evolved body of scholarship on that. And there's a certain contemporary context to that literature. And what does that literature tell us? I think Sudhir in his first talk has also made references to some of that. India plays a certain role. Mark Galanter's 76 articles, Scholars in Self-Estrangement, sort of cites India as an example of why the law and development movement, which started in the 1950s, was built on false premises and should perhaps be dispelled. So David Trubeck, who did his work in Brazil, and Galanter's work on India, they sort of use that to say we should be careful about these assumptions that changes in law can bring about changes in societal development, and one has to be sort of skeptical of that. So what I will do very quickly is to also, there's a book, and perhaps as part of this exercise we should also be looking at what kind of scholarly literature to engage with. So the conference that was organized for the Law and Development in Asia book looked at a more recent book by David Trubeck and Alvaro Santos. It's called The New Law and Development. What it analyzes, and that's the interesting thing, so the comparative dimension. India is obviously not unique in dealing with legal and judicial reform. This has been a program which has been on for the last 20 years or so, and that literature on law and development sort of documents that. And the scale is pretty phenomenal. I mean, so another book to sort of look out is Thomas Carruthers' Aiding Democracy Abroad. So Thomas Carruthers is now with the Carnegie Endowment, he's with a think tank. But for many years, he was part of the legal and judicial reform establishment in some ways. He worked with USAID. And some of the statistics that are going on are pretty phenomenal. So along the same time when we've been discussing reforms, this has been the story across many, many other countries. Right? So let's think of some of those statistics there. So the USAID spent annually US $530 million every year on these legal and judicial reform projects. And these projects encompassed many, many countries. Let me just try and give you a list. So not just countries, continents, right? So across Latin America, across Africa, and parts of Asia. The World Bank, this is Alvaro Santos has done some pretty interesting work on how much the World Bank has spent. So between 1993 and 2006, the World Bank has spent $3.8 US billion in about 100 countries trying to get about legal and judicial reform. Right? So we talked about the budgetary implications, but let's also think that there's an incredible amount of money which has been spent over the last 2 decades in many, many countries, many of whom are in the developing world. And so Carruthers and Santos are people who've sort of been consultants in projects. They are not your critiques of the World Bank and aid institutions from the left. These are people who are part of these. But they themselves say these projects have by and large been failures. They haven't achieved very much. Why is that? And that, I think that literature is interesting even as we study what's happening in India and what are the sort of causal factors of not achieving success. Right? And we know the usual sort of, I think both Nick and others earlier, and people have sort of tried to say, what are the numbers? How do you get data? How do you sort of get to it? Going back to Pratap Mehta's way of setting it up, these are wicked problems. When you've tried to reform the system, there have been unintended consequences, and one has to sort of worry about how to sort of get towards it. So Carruthers in particular says there are some reasons why these judicial reform projects sort of failed. And he said, first, this requires huge resources, right? So we've seen people of Vikas's presentation throughout numbers of how much it would, even if you went along things that have been suggested, how much money you will need. And that's the case even in smaller countries. These kind of things require tremendous resource allocations, and there are gaps there. One important factor, and for us that was a distinguishing factor between reforms in Singapore and reforms in India. So yesterday's panel we looked at the CPC amendment of 2002 and how a lot of that was really blocked up. So when Justice Ahmadi was in the Supreme Court, we've seen that period was regarded for a while as a successful period when the Supreme Court sort of made a significant dent in its own pendency. Now we know that story is a bit more complicated. Some of that was just a question of changing the labels, classifying it differently, getting the district court judges in sort of helped in some ways. But that's also more, whether that's a success is one has to be more careful about labeling it a success. But if you look at the people who were involved in that Indo-US Legal Reform Committee, which is quite a massive exercise, and they went around, consulted many people. And what is interesting about that report was many High Court judges, many Supreme Court judges, and lawyers from the legal across India were involved in that. So although that was a US team, there were Indian lawyers also involved. And those reports are also interesting. It's perhaps one of the more recent sort of large-scale exercises which try to conduct that kind of an exercise. They gave us, a number of reforms suggestions, which got held up also because the organized legal profession completely opposed that, including things like time limits for adjournments and all kinds of things. And for us, one of our conclusions is in Singapore, Chief Justice Yang Peng Hao could make these reforms work because of the overall political context, right? The fact that there's been a single party in power for all of its post-independence existence, and that party was very much in line with reforms because legal systemic reforms were seen as crucial for attracting foreign investment. So going back to Simon Chapman's sort of presentation, if there is if there's consensus across society that we need a better legal system because that will improve foreign investment and economic development, then that can be sort of worked out. But as we've said, there's huge question marks about whether there are those direct linkages, right? So you can take, people have said, well, you need legal and judicial reform, you need liberal sort of regimes and contract and property regimes because that will aid investment. Well, you look at China and Singapore. These are two societies which don't have independent judiciaries, which don't have strong property rights regimes. They have huge foreign investment, right? So you also have to make sort of value judgments about what are the things that you want to give up in order to have efficiency, in order to have a very, very fast system, right? And it takes me back to, and I think the way the framing paper set it up, that when you're looking at legal and judicial reform, you have to think of what is the overall approach that's going to guide you, right? So the World Bank has always used rule of law as a way to sort of endorse these kind of systemic reforms. But access to justice, if you want to take that seriously, the Singapore system is extremely efficient. The Malik report calls it amongst the world's most effective, efficient systems in the world. But it is also one of the world's most expensive systems for citizens to access, right? There are no rules of standing. Very, very high thresholds for getting into the court system. And that's something we have to think about. I think there's been research Nick and Varun Gauri have done. There's this, again, the myths about what causes clogging, right? So one of the myths about PIL is a source of great pendency is by now quite established by their research. That's simply not true. PILs do not constitute a bulk of the caseload, the areas of the court. So you can still have a system which is accessible and yet be able to sort of produce things. So the story in India is not that PIL has clogged the courts up and you can't access the system. So that's so far as our study was going, and I'll probably stop that because that chapter can be circulated and other people can sort of talk about it. But coming back to the reforming the court system. So nothing particularly novel here, but I want to see why we can't push things through. So Mark Galanter's name has been invoked several times, and one of the interesting things which I don't know how many people have access to, but his affidavit in the Bhopal gas case is fascinating, and I wonder why he's not tried to publish it. One of the things he does there is try to examine why is it that 136 has become this huge behemoth in some ways, and why does it attract so much? If you look at the original reasons, and 136 is a very strange provision if you look at it from the field of comparative constitutional law. You look at the language of it, technically, if I'm in the small causes court in Karnataka, and it's a 2,000 rupee dispute between me and a friend, and the court orders me to put in that money as a security by way of an interim order, I can technically, by the language of the provision, go right up to the Supreme Court saying, I have a problem with that. Now, why was it put there? Galanter's done some research on the thinking behind it. I don't know where I think some of it is speculative. And he says the speculative function is, again, we talked about the colonial hangover. In 1950, there was this problem, much more than today, of finding personnel who could man this system. Right? And also because of the colonial system, which was deeply distrustful of Indians as judges, you had a system by which you had to also deal with the transition. And if you did not allow that, what you would have had would have been people at the low, and there was this problem of people at the lower levels are just simply not competent perhaps. And so the idea that you put your best on the highest court, and that higher court sort of does some quality control or whatever, and even if there are errors down below, you mitigate that by allowing the Supreme Court to have 136 to redress that. Now, that may have been the original sort of thing, but if fast forwarding 60 odd years later, we're still continuing with that system, that has huge implications. What it also shows is that the judiciary does not trust its own lower orders, right? And we've talked about, I think Sidharth's presentation was interesting about how many district court judges have become Chief Justice of India. That's a very, very low number. And very often that number, you have to look at other factors of, was there a regional or a religious representation question involved which allowed that person to sort of get in. So there are all kinds of internal biases that we have in a system, which for the system itself is not good. For the system to say we do not trust lower court judges, and that's why we have to keep on intervening in 136, is not a good way for the system to progress forward. Right? There has to be decentralization. There has to be a sense of saying we stop. The other thing that Galanter records is even today in the post-independence regime, the number of appeals we allow is simply inexcusable. Right? Why is it that there are so many appeals allowed at every, and he said that having innumerable appeals obviously served the colonial judges' judiciary's purposes, where ultimately they had to ensure that there was an Englishman who could handle it finally, and there was no insurrectionist Indian native judge who was going to give some kind of diabolical interpretation to a law, and that served it. But today, 60 years after independence, that doesn't serve much of a purpose in the same way. It probably serves purposes. The question is to sort of question them and then think of how to do it. Now, I understand that this kind of fundamental reform is going to be very hard to do. One of the things that Pratap Mehta said, and I think we've all had a discussion, most of us who are lawyers and have been involved in the Supreme Court were quite defensive and pushing back. But one of the things that he says about it being a guild is not, and lawyers being rent-seeking and judges being, is not problem. It's not just a problem for the rest of society. I think it's a problem even for the legal profession itself. So anyone who's tried to practice in the Supreme Court or on the High Court, this big question comes up, why are these National Law School graduates abandoning the professional system? But having worked in that system, I think Nick and Mark Galanter are doing this fascinating work on the senior advocate system, which they've, I think, quite charitably called the grand advocate system. But there are serious problems with that. We have a very strange legal profession, which is structured in a very monopolistic way. It does not encourage people who are young. I mean, to be told that you enter the bar and you work for 10 years, there's a famous senior advocate who said to a colleague of mine that I lived on bread and omelette for 8 years, and that's how I came up in this profession. I'm not sure one can expect people to join a profession if that's the story you're going to say. And of course, it's deeply problematic. I mean, the exorbitant fees that senior counsels charge, as they say, the top in the bar, are by far the most successful and the most wealthy lawyers in the world. There's just simply no question in terms of the fees that they charge. And so you have a very odd system which has been allowed to exist, which does not serve the legal profession itself well. That's why there is attrition. That's why young people are not attracted to join it. And those are the kind of fundamental reforms that I think we should be talking about. The oral tradition, I think Menaka said, you know, there's a difference between the way we discuss things. And of course you're right. The Indian Supreme Court cannot try and adopt a model as the US Supreme Court does of just 30 minutes. But there is also, I think, this myth-making and this tradition. So if you read, I mean, for me, it's one of the striking things in Justice Chandrachud's dissenting, well, it's not dissenting, but his separate judgment, let's not get into a debate of whether it's dissenting or not, his separate judgment in the Keswan and Bharati cases, he does a sort of empirical account in the first few paragraphs of how long it was argued and how many people spoke and how many hours were spent on the case. Now, many of us take, you know, justifiable pride. You talk about the argumentative Indian tradition of using that. But you take something like Obamacare, which is now being debated, the Affordable Care Act, which is a huge, here's the US trying to, for the first time, bring about healthcare reform in a country which has a 250-year-old history. And it's a hugely complex issue. Yet they've managed to stick to that deadline of 30 minutes per lawyer, right? Okay, go to 3 days, right? So you extend it, so 30 minutes to 3 days. I don't see why, I think it's a problem of the tradition that we have. We simply do not have a brief writing tradition. Even the grand advocates who are otherwise great at oral advocacy, how do you substitute that with a system by which you can involve briefs and get to change that culture? Right? So in some ways, I think that when people like Pratap Mehta attack the institution as responsible academics, I think it's incumbent upon those of us who constitute the profession as academics, as lawyers, as judges, to perhaps take that as a way to think of fundamental reform in some ways. And perhaps we're quite accustomed to these things, and to us it seems normal and explicable by all kinds of reasons. But when outsiders sort of come in and look at it, it does seem very, very hard to justify and say business should go on as usual. I'll stop here because hopefully we'll have a good round of discussions and more people can sort of pitch in with what they want to say. Thank you.
Should I just summarize in a minute? I think we're still grappling with why do we need reforms, towards what end, and once we are able to answer that, and I'll take on some of the things that had been discussed, particularly by the last speaker, why can we not limit the time for a matter? Again, it's a problem of quality that, you know, all of us agree on, because either lawyer cannot take it for granted that you, the judge, have the kind of knowledge on which I'll base my argument. And it is the other way around also at times, that either judge cannot expect that the question I put to you will be correctly understood by you in the context that I make that question. So therefore, it's a problem of quality. And as we churn, as we improve, as we, you know, kind of sophisticate the system, we'll probably develop this quality bit. And of course, the other thing that, Arun said, and which I would add my personal experience, and I've said this before, that when I first went, as a very junior lawyer to the Supreme Court in the early 90s or so, I would find that there would be judges who'd been there in the Supreme Court for maybe 2-3 years, and they would be addressing prominent counsel as Mr. Counsel. That's because there was that distance. And I think now that a judge who enters the Supreme Court knows the counsel already by name. So there is something, there to reflect on. But, there's one further aspect that even if I am delaying my, leaving for the airport and I have an early flight, is that there's one gentleman, Mr. Arun Mohan in Delhi, who's given up a lot of his work and an entire career to work on, the judicial reforms. And in one of the booklets that he's published, he's made a pie chart of, on the civil side, what is the percentage of litigation, which are genuine and what are bogus. And he says that 5% of the litigation, civil cases, the voluntary litigation, not the involuntary type, 5% of the cases come in because of error on either side in perception of fact or law. And he says there's another 5% where there is actually judicial intervention necessary for the bona fide dispute, which cannot be resolved. And he says so far as the balance 90% is concerned, most of them are profit-making and bogus litigations. And he says that on the basis of some empirical studies, not perception, not throwing it like I would, and he says that that is probably because there is a deficiency in how the matter enters the system, the lack of quality in how the matter is presented to the court, the lack of quality in how the matter is assessed by the court, which requires correction at various levels. So therefore, you have the area of dispute which may be very small, enlarged and expanded because of lack of quality, because procedural requirements have not been met, because it's been wrongly assessed, it's been wrongly presented, it's been wrongly interpreted. So these are various factors, which go into the problems faced at the appellate stage. And that may be one of the perceptions that, why Article 136 has been used, so charitably, because it's a perception that correction is necessary in the interests of justice. So can we have some questions, please? And I think we can all come up here and take the questions immediately, please. I'll do the standing and fielding. Yeah, we can hear you.
First of all, let me congratulate the three judges who've come to this conference and who've opened themselves up to this kind of discussion. Because as a practicing lawyer for more than 11 or 12 years, I find it very refreshing that this sort of thing is being done. Very few judges would even consider, I think, coming to a forum where the way in which courts are run, etc., are being questioned so openly. So I think that itself is a great step. And the fact that in India, the judges are so well insulated from any sort of criticism. You have the Contempt of Courts Act. You have the constitutional traditions which don't allow you to question anything about the judges' appointment, so on and so forth. I think if reform really has to take place within the judiciary, it would have to come from the judges themselves. We want it quickly enough. Unless there's some sort of revolution in the end, when the judges would have to concede, okay, but if we want it quickly enough, we do need enlightened judges. And I can only hope that more such judges will join such forums and take part in such things.
That may also be a matter of some empirical research.
Yes. lecture in National Law School, some student asked something, and the question was asked to a retired judge, and the retired judge retorted something to the effect that the contempt of law provisions might be used against that student. So, this was the level at which debate used to go on.
Sadly enough, and I think both Murli and Ravi will corroborate, I still cannot expect too many, kind of scenes where I, the judge, am standing there, you, the non-judge, is sitting down and talking to me. And unfortunately, that is how we come through. And the sooner we get over this, little messages in course of communication, the power struggle that, that is the story of man. And that has to change before we realize what the obligation of the judiciary is.
But Sanjib, you might just take 1 second to tell them what the range of dialogue has been going on
At the National Judicial...
where Prashant Bhushan, Medha Patkar, and so on have been dialoguing with the judge. You might want to...
Yes, and we've had people, the expected where people are up in arms, but then we've also been able to hear them out, and with some persuasion and some effort of Professor Mohan Gopal over time, until such time that my colleague from Calcutta, Justice Dipankar Dotto, asked Arundhati Roy, or Medha Patkar, that what do you think about courts and judges? And she was so taken aback that a judge would even want to know what her view was. But in course of, dialogue, in course of the atmosphere that was attempted to be built, we've had that kind of a thing. Yes, sir.
I just have some data on senior advocate designation by the Supreme Court. So since 2001, 80 senior advocates have been designated by the Supreme Court. 64 of them were ex-judges, 16 were advocates, and 5 of those advocates had legal family background. Their father or somebody was practicing. And how many?
One.
Actually, the entire list from 1950 only has 6 women. 427 senior advocates, it's only 6 women. Right? Yeah, 3 of them. You are saying the first one.
No, I was just going to ask Sidharth and Arun. See, I've been bouncing off a range of law students who come out. See, with computerization, now you have the entire cost list of the Supreme Court available. And if you look at the cost title, you will have the subject category. So you are able to kind of precisely say, even within a labor dispute, whether this pertains to dismissal or promotion or... Now if you take up an order passed in that petition, which should be on the net, you can match the order with the case. Then you subject it to a critical analysis for, let's pick up senior advocate biases. So what is the chance that if you engage a senior counsel, you might get notice issued in your special petition? And over a range of cases, then you can pick up labor cases, cases involving women, children. So it's very important as an institution for us, even as, High Court affiliates get very complicated, but from the Supreme Court's point of view, you should be able to tell the Supreme Court, listen, this year, let's say 100 workmen approached you with their SLPs, and you admitted 80 of them, or you dismissed 80 of them. Now, this is an institution, it's not judge specific, so you won't be in contempt. You're not alleging bias of any one particular judge, but an inherent bias of the system. So you're also telling the Supreme Court, listen, it is more likely, you may not intend it, it's more likely that when people engage a senior counsel, they're able to get that case past you, past the first stage. Or you may even disprove it. You might show actually the Supreme Court is completely neutral to this, and it doesn't make a jot of a difference whether you engage a senior counsel or not. This feedback is very important to the litigant, because a litigant in Calcutta or in Thiruvengadam is told, listen, if you have to carry your case to the Supreme Court, you need to keep aside 5 lakhs of rupees. Otherwise, you can't even think of the Supreme Court. And now we are in a position to do this kind of analysis of the behavior of the court. And we can do it subject category wise. And over length of time, we know for a fact, Arun, I mean, you talked occasionally at the Bannerjee, but we know for a fact, I know for a fact that JMM, Bradley case, went on before one bench for 3 months. When it was referred to the larger bench, it went on for 2 months before that bench. Alright? And now we know in the recent past, there have been at least 2 huge corporate litigations, which have gone on for months together. So in the Supreme Court, you're able to analyze what is the percentage of time devoted to cases. Right? We can do this time analysis.
And categories.
Yeah, because, and it's happening all over the country, judges don't necessarily sit from 10:30 to 4:30. Right? So we can actually see the number of judicial hours spent on cases. That's possible in the Supreme Court. It's definitely possible in the Supreme Court. I think it's an important feedback to give back to the Supreme Court, saying this is exactly the number of hours you spent, and what is the proportion of time that you spent on cases, and on whose kinds of cases.
Yeah, it's very important because even at the High Court level, we see that there's a lot of determination, allocation of business following representations from the bar. And that is so skewed. It's not service matter oriented. It's not, labor law or education oriented where you have more filings, but there are other considerations that go into it. And the Chief Justice or probably the judges have more to react to the representation from the bar than what they see on paper, because these statistics are available to the Chief Justice and the judges.
And the last one from point of view of High Court judges, I think each of us agrees from previous. How often are High Courts reversed in the Supreme Court?
There was a study yesterday.
Yeah, so I'll just mention, one thing that, and it's ironic in a way that 2 Cornell professors are doing this, but Ted Eisenberg and Shihal Kalantri, who we presented yesterday, they're going through this is one answer all this time. They're going through all of the judgments from 2010 and 2011.
Yeah, not judgments, because I'm talking your orders. You see, what happens is at the first stage of the Supreme Court, when you dismiss the SLP, you're affirming a judgment of the High Court.
Oh, I see what you're
Yes, so it's not enough to go by
It's
judgment.
not enough because there is a large category of cases where it could be either remitted or the judgment is set aside by consent without reasons.
And with 2 paragraphs sometimes. So you have smaller orders which reverse or affirm a judgment of the High Court.
Right, I think that's right. And all I'm saying is, so there's the first study that I know of that has tried to at least try to do this for the judgments, not, all of these other factors, which are actually much more interesting in some ways to the judges. I think theirs will be interesting for other reasons. But that's the first study I know of that type that's kind of doing it a couple of years. But
But the answer is Sidharth's point. You see, he presumed, and I think it was a set of presumptions, for what kind of qualities are you looking for appointment to the Supreme Court.
No, I think that just been done.
No,
No,
but
but
still.
it's useful. You see, the point is,
We didn't know it.
yes,
And we haven't worked on those aspects,
I can send my information.
No, but I tell you what, taking off from where Murli, I'll just one further thing. I think you'll find some people, some judges who can help you with the analysis, because that is crucial. I'm not saying that you don't have the experience, you don't have the knowledge or the expertise, but if you talked it over, probably another aspect could be given.
And especially when I found that although the topic was quite broad, there was hardly any discussion about the high courts and appellate courts. And we also have appellate courts which are district courts. So obviously it takes a lot of humongous effort for that. But for that, I can only make some observations. I think part of the problem which is not seen in this kind of research is that the cases that you see, the filings, and what goes out, you just get to see the end results at the point of entry and the point of exit. But the number of times it is listed. Now each, if you gather that up, for instance, the 60,000 cases which might enter a system, might actually be listed about 400,000 times a year, which means that how much time does the judge get to spend on this, apart from other considerations. So then the second thing is, this is not often discussed, but it's one of the most endemic issues. I think it's a very important, perhaps very sensitive issue, is the turnaround for the roster time. In most high courts, there is no stability. From all accounts,
Ad hocism.
high courts judges, Justice Bannerjee might be hearing a particular case, and then that whole roster might change within, I think in your court it's 6 weeks or 2 months.
So it's about between 3 months and 6 months,
In our court it's
depending
usually
on the
6 months.
indispensability of the judge to that particular determination. That's
Just
some kind of
because I've been
sophistication.
on the arbitration side for a year, I have been on the criminal side for a year and a half. These are kind of unusual. So there are, but these are exceptions. So this and how much it tells on the efficiency and the disposal. I know there are lots of other factors which are actually masked by this disposal. And then of course a lot of issues about infrastructure. And one comment I think about the what is again hidden about the appointments which I think you made in your presentation was the fact that there have not been too many bar appointments in the past.
No, recently in the High Court. In the High Court.
In the High Court, the appointments have been held up. There's not much analysis. In fact, for the past 2-3 years, most of the appointments made to the High Courts have been from service. So other qualitative comments that you made about disposal by service judges or well, there could be debates on that. Let's not get into that. And then even the composition of bench. The very important issue is the tenure of the Chief Justices of the High Court. There's hardly any stability and they're mostly seen as birds of passage.
Yes.
Which means that the High Court doesn't see direction. There's not much thinking about it.
And there's no passion because that's not your own High Court, because you're looking elsewhere.
No, because you're expecting the promotion.
Exactly.
And therefore, as a result, you have a lot of other issues cropping up because there is no continuity in the administration. And the whole constitutional structure here is the Chief Justice controls the High Court. Article 229. So,
And the lower courts, that power is even stronger.
No, that the High Court does it. Chief Justice does not do it.
On the ACRs, the decisions on
it's on the
High
High
Court.
Court's power.
It's a collective authority of the High Court, not the individual.
But what is astounding is on the administrative side of the entire judiciary, it's only the CJI.
Only the CJI.
The CJI does not distribute his administrative powers to any collegium. It's only for appointments that he consults a collegium. So, much difference. Yes, that is the Supreme Court.
Yeah.
It's completely different. So one small comment and small clarification I would like you to make, particularly to me, but I think it is all those who presented the data. I'm tempted to say that my feeling is that probably there are two aspects to data and there is a collation of it, and that's probably a problem. One is the curative aspect, the other is the representation. And I'm wondering whether you would see curative as a perpetual problem, and I think it exists in any system, and you need to handle that curative aspect as a separate thing before, so therefore you don't need to footnote the kind of thing that you're representing with the curative aspects every time, that these are not probably correct, or there are many errors, etc. That you need to handle probably, I would submit, a separate level in terms of dealing with it. A general footnote to me is sufficient. But I'm wondering, my question is whether in the representational aspect of data sets, whether there is possibility of, because what is presentable in this short presentation is only macro overview. Obviously it is too light in terms of whatever it is presented. What's the possibility of bringing depth to the data sets, number one, and whether, for instance, there is any movement towards the possibilities of working towards an annual statistical book for the judiciary, sort of a thing. In other words, there is a possibility of systematizing the representational character, bringing depth, and the curative aspect then becomes the backdrop to the kind of mode that you will do. So I'm wondering whether there is any such.
May I just interrupt for a moment, in this, I have a flight to catch, and may I have your leave? Thank you.
Thank you.
So I'll just anchor questions to carry on. Continue, Ram. Yeah. There were some other hands up that I saw. So, any other questions? Yeah, sure.
One is, I think, clear from all this, the presentation, that the quality is that we now do not have, except in very limited cases, we do not have data that can provide a sound and robust basis for drawing conclusions or developing policy. So we have to be, we can't say both things. We can't say data is terribly bad and then say, oh, these are our conclusions and these are the reforms. So we have to be very careful. The second thing is, I think we need to be careful not to limit appeals, given the realities in this country. I mean, they can all tell you about the kind of horrendous, interventions that sometimes have to be made. And given the quality of judging that is going on at all levels, not only, I won't say judging, judicial processes, the entire judicial process, I think we must, and people like Menaka who are at the Supreme Court are trying to correct this, what goes on at the lowest level. I think we need actually to further open up the avenues of the Supreme Court rather than close it and say, you've got too many cases and so on and so forth. At least until such time as the quality of justice at the lowest level corrects itself. And lastly, I think one point that we did not cover here on this appellate court role is that the role of the High Courts is being actively undermined through the independent regulatory authority route. So many of these tribunals are being made, and so much of civil litigation is being diverted into these tribunals. And the High Courts are being removed from these tribunals as appellate courts, and the Supreme Court is being made the court of first appeal from the tribunal. And so in a sense, what the High Court as a supervisory body under 227 of tribunals, that role is being statutorily undermined. And I think this is a very dangerous, both tribunalization and the diversion of High Court jurisdiction away from High Courts to tribunals and then to the Supreme Court, knowing that the Supreme Court simply does not have the capacity to absorb all this. I was a member of SEBI and I saw the enormous danger of this in actual operation, where a lot of wrongdoing going on in SEBI. High Courts have no jurisdiction, and recently the Bombay High Court actually stepped in under 227 on the SEBI matter. So I think the role, what is the architecture for appellate courts in our country? What was the constitutional vision? How executive activism is now undermining it, mainly driven by the bureaucracy. I think we have to restore high courts as the appellate courts of the country, and the Supreme Court as a kind of constitutional court, mainly as it was intended under Article 32, mainly as a guardian of constitutional rights. And we need a vision on what should be the architecture of the appellate process, because High Court is also not a court of first appeal in most cases. The District Court is an appellate court for a large number of cases. So we need to rethink that architecture, I think, and take action.
Yeah, are there any other big questions? So if there are not, I'm just going to take a minute to respond to some of the points. I had my hand up, it's not that I'm here, I can recognize myself. And then I'll just turn it off to the panelists before we close. My approach to thinking about Nick and Sidharth's presentation and some of the data that we produced, we're on very similar terrain and we've been talking for some time, is not caution. I think we should blaze away. I would take a very different view about what kind of accountability is necessary in the judiciary. I don't think we need to have, we need to tiptoe around these problems and sort of manage institutional reform and change. I know that these are complex problems, but I sense that there's an urgent need, and Pratap put it very well yesterday, that whether the judiciary wants it or not, horizontal accountability is coming. And while the court may have played an active role in promoting horizontal accountability in other arms of government, it will now come to the court. And when that comes to the court, none of these internal logics and explanations that we offer for why we are hamstrung by ourselves is going to count for much. And so my sense is that it might be good to preface that public blowback by taking it very seriously ourselves. And so I know the intensity of the effort it takes to produce that from the quality of data that our institutions have. And so my response is that we should do much more of that. We must be careful and do as much of that qualifying as we can. But really beyond the point, I take your point, Ram, that we should say it for what it is. And if the data is wrong, then the institutions should do their job of correcting it. And I say this in a particular context, which is that the Supreme Court data is the most inaccessible data today. So the institutions themselves have not grappled with the idea that they should make all their data public. And by all means, we will refine our techniques. We will hold ourselves accountable to the highest academic standards to do this work the best that we can do. But if the institutions and the allied institutions of the court, whether they be the academies and so on, conduct an internal discourse on internal data that is horrendously difficult to access, then they will have to, in some sense, we will all have to cope with that poverty of data, and we work with the best that we can get. They may have some access points, we may have some other access points. We work with the best that we can get. And so my sense is on the data question, I think that insiders and outsiders have to talk very differently about data. We can talk about how data is inaccessible and the poverty. Insiders don't have that luxury, as far as I'm concerned. They have to produce the data. They are responsible for the production of that data. So they have to give a different account of why the data is bad. I have just two more quick comments on causelist analysis. I know Bhavin Patel sitting at the back of the room has kept quiet. I thought he might jump in. So there is some interesting computational analysis going into causelist data, addressing some of the questions that you've asked about how often do cases go back? What is that kind of repeat cycle? It's a huge computational problem, apart from just how you code analysis of this very vast, it's a big data problem. Causalists are huge. And for us to analyze High Court and Supreme Court causalist data in this way is something that we've already put our minds to, but we're not at a stage where we can say something significant as yet. And my last point was about the focus on high courts. In a sense, we as researchers are going where the data is. In terms of appreciation, we appreciate the point readily that the high courts have handled many more cases, in fact, than the Supreme Court. And all of us who are interested in reform should be concerned about the high courts. But in a sense, that is a problem that we're getting directed to where the data is available. Those are the three short points that I wanted to make. But I'll hand it over to the panelists to have their last words, and you have a mic. Yes.
Document the problems, the efficiency losses on account of
existing part is breaking down by very complicated. This is much harder. So to crack the roster system, you also have to know how benches are twisting. And if you're not a practitioner, if you're not a parent in that code, and if you don't have those networks, it is very hard to get contact data. But hopefully the judges like us have things to improve. Yeah. No, I know Delhi High Court is excellent. Delhi High Court is probably amongst the best access to this data on bench listing and composition. So I think that's the first place we should look at. And I know some of the other courts are also very good at that. So I think that's probably the next level. And then lastly, sir, on the university sitting issue, of course, we have the Chandra Kumar, Sampath Kumar line of cases which is still pending before a 9-judge bench. And no one knows when that 9-judge bench will come up. The rumor is Justice Kapadia wants to actually hear it before he retires, but there are many other cases he wants to handle before he retires. So we don't know whether that question will get resolved. It's like that Bangalore water supply storage board, the definition of industry is late. So maybe it gets resolved sometime in 2050. Then we can answer that question about practical regulatory bodies.
Nick.
I won't say that many comments. One thing just on the comment of this, why I highlighted all the problems with the data that is going along so much, was in part because, this stuff is too dry from outside. Most people in the public, I just figure you're one of the few audiences that might have some marginal interest, like the nitpicky, like little details. Yeah, we've been waiting for an audience for a while. So,
And I'm gonna close with that point. Yeah.
But I also do think the original idea I think that we had was doing this paper was so, and rather than taking so long, it clarifies to me as much as possible. Because as I went to try to address some of this or write about it or address it, I just realized there weren't answers or that at least were written down anywhere in one cohesive document. I thought if we could just get a document that said where we are in 2012, of our understanding of this data, that would be a good place to start, right? And then we can go forward from there. We can have debates about what data we want to collect. And I do think there is an interesting kind of ethical responsibility that comes with data. I am a proponent, I think, of this idea that it's going to get out one way or the other. Ken Chital from Cornell just collected judgments and, document them from the U.S. if people aren't doing it here. It's going to happen, right? It's going to come out one way or the other. But I do worry about, data's also where the power is. A lot of people don't understand data. A lot of people don't understand statistics. I think it's actually where kind of control of the judiciary and the judiciary is going to go. I think the people who have the data will understand the data,
Absolutely.
guiding and directing this debate. And there's a danger in that because people don't understand it, you can put prescriptions out there that might not actually, it might be one possible conclusion of the data, but not the only possible conclusion. If you can have a small group of people who have access to the data and understand it, setting the agenda for the entire court system. But I think because of that, it's really important to get the data out there. I say this knowing the paper is long overdue. But my idea was just get the raw data set out there so multiple people can have access to it. Because you don't want the power clustered around a small body that understands it. So I'll just comment on that.
Yes, Arun.
Just the question is, so why do we have long arguments? Quality and speciality not there, and so it's common. My sense of this is these kind of questions are coming. People who are in the system and are dealing with it have a sense of a different sense of clarity, and they are caught in the present. From my point of view, if you look at the 1950 situation, they felt there was a crisis then. We have to have 136 and we have to exercise visibility without thinking of the consequences it will have for the system over a period of time. So if you say now the crisis is there, we know all of that, there are no sane people, one part of the conversation is real education in the country and 900 schools and what's happening in that. But you have to think on that longer span. If you keep dealing with contemporary crises and then say, no, we have to still, we all know the answer is bad, but we've got to continue because we don't trust the people down below at the High Court level. And just to Dr. Gopal, those two arguments are somewhat contradictory. Because if the system is so bad down below and the only thing we can trust is the Supreme Court with the great 30 judges, then I don't see what's the problem in outsourcing it from the High Court to the tribunal. Both can't stand. It can't be that there's something sanctified about this wonderful system which we have to preserve. And at the same time, we keep saying it's rotten in some ways and the quality is bad. So those two arguments you've got to reconcile in some ways. I'm not saying that that's not true. I think what you're saying is that, but we cannot with a straight face say the reason we have one doctor. There's horrendous stuff going on at all levels. Right. And it's not, well, it's not, let me be a bit more provocative and say, I'm not sure that the evidence of word quality. It's not clear to me that after 7 APUs or whatever, the final resolution is actually that just at the end of it. Are we doing damage control? Are we doing what's coming out of the product? At the end is also all notice. Across the board, if you just take the Supreme Court and the quality of the judgments from the Supreme Court, if you take the court, and now people are transcribing hearings before the Supreme Court, and that's becoming a really good. It is depressing reading that transcript and seeing the quality on display, that the reasoning and everything.
I'm simply saying, I love when you're very diverse and views, thank you. I love, being liberal about, don't have, close the doors for appeal.
But liberalism, I guess, also means
Third jurisdiction also means about 25 to 30,000 filings before the US Supreme Court. It's just that the route that they have chosen right from inception is not to have a hearing, but they still deliberate and vote on each petition as to what should be interpreted. They do spend a tremendous amount of time in doing so. At least every law class looks at it. Whatever is the process. So out here we have taken another route that we have a public hearing which takes 2 days. These are different values.
having been a member of the Supreme Court bar the Mondays and Fridays, I don't know if it's done. It's even more disturbing watching that.
Sure. Yeah. I'll just, we thought we would have that, and we invited someone to present on that very specific proposal, but unfortunately they couldn't be here. So that bifurcation of the court into Court of Appeal and Supreme Court was a question that we considered. We even have done some quantitative numbers on what that might look like if we achieved that, but we couldn't do it for this conference. So. Sure.
That's a better comparison.
Sure.
Constitutional courts of Africa and Indian Supreme Court. That's not a comparison.
Okay. I'm just a little conscious now about time. I should say two things. One, that the spirited exchanges around the panel suggest that at least a good number of people think there are important things being discussed. I would also say a second thing, which is that one of the purposes of the conference is to constitute an independent field of inquiry, not a government field of inquiry into the court system. And this is something that Pratap Mehta spoke about consistently yesterday, that people who have intellectual and academic abilities need to take the court system very seriously, and that we need to do independently of government and the judges and the lawyers. They may all have very different interests and persuasions of why they would come to this field, and I think the people on this panel may have different persuasions, and my sense is that to that extent, that independent field, I'm not suggesting these are the first people to do it. It has never existed as a serious subfield. There have been isolated studies. You refer to Kidder and Moog's work, Dhawan himself on the SLP crisis in the 80s, Bakshi in crisis of the Indian legal system. There have been isolated work. What we're trying to do is to bring it together and bring people who are interested in these questions together at an academic forum, and that's the sort of design of this conference. So thank you very much. Thank you to the panelists. We have lunch upstairs, and we will start at 2:15, which is a 15-minute delay on the schedule. Thank you.